Good afternoon, everybody. Thank you so much for coming today on our surprisingly beautiful day. I just have a short presentation today about estate planning basics. I think it's some important information that everybody should know about, and yeah, we'll go over everything. For those that you've attended one of these topics before, hopefully you have some new perspective or learn something new. And for those of you that this is your first time listening to a presentation of this kind, hopefully you can take home some considerations, things to think about when going over your estate planning. For questions, I don't mind if during the presentation, if you have a question, please just raise your hand, and I can bring the mic to you if you want, and then we can do that as well. And after the presentation, we'll take some questions. And if you're shy like me, you can come up after the presentation, or you have a more private question. I'll be sticking around after the presentation too, and then we can have a little chat up front here. And just to check, the people in the back, is it okay? You can hear me clearly? At Archbishop Carney, right by the Costco there. I did my undergrad in biochemistry at UBC, and I've also done my law school degree at UBC as well. I've experienced working at national-sized firms as well as mid-sized firms, so I do have experience working with all different kinds of clients, but my favorite is folks like you, and I'm coming up to my 6th year as a lawyer. My areas of expertise are real estate law, wills and estates, and corporate law as well. So these are the 3 important documents that I want to talk to you about today. First off is the power of attorney. That one's used for legal and financial matters. We also have a representation agreement. You might know it as like a healthcare directive. They had different names before. The legislation has updated throughout the years. But the gist of it is that you can appoint a representative to help make healthcare decisions on your behalf, whether you still have mental capacity or not, is useful in all circumstances. The last big one is the will. That one is where you would appoint your executor. That person is your trustee to help you administer the estate, as well as where you can outline how you want the assets to be distributed among the beneficiaries. So we'll go into more detail for all of these. So first off, the next topic is the representation agreement. So much like the power of attorney, you can designate a representative. Again, the same criteria works for this one as well, to someone that's trusted to deal with your healthcare decisions. I find this document is also helpful, even if again, you're healthy. They can help take appointments, make healthcare decisions with the doctors. Perhaps you're not feeling up to go into the doctors that day. They can go on your behalf, get confidential information, and make decisions on your behalf there. What's important about this document is that you can designate exactly who you want to make healthcare decisions on your behalf. So for different healthcare providers, as you might have experienced at like maybe the hospital or different clinics, they usually defer to next of kin. For a lot of us, that's pretty obvious. It could be like family members, brothers and sisters, and they have a criteria they go down. But for some of us as well, this could be not as clear. Perhaps you're in a blended family. Do we go with the new spouse or partner, or do you go with your kids? So in those circumstances, I think it's very important that while you can make these documents, you have that prerogative to pick exactly who you want to represent you in these healthcare matters. This one takes effect upon death, and the main purpose, like I said earlier, is to designate your executor and determine how your assets are distributed. I just want to give a very quick summary of the probate process. So when someone passes away, the court will have to approve the will to say, yes, this will was executed properly and it's a valid will. So that process is called the probate application process, where we would submit the original will to court. They take about 3 months to examine it, and they would come back with a grant of probate. So that grant of probate is what gives authority to your executor to help deal with the estate assets. The whole process usually takes about 1 year or more, depending on the complexity of the estate, but it is sometimes quite an endeavor to take care of.
If you have a will and you will your estate, say an apartment, to your kids or grandkids, does it still have to go to probate?
So the question was, if in your will you've designated your property to go to your kids or grandkids, and would that estate still have to go through probate? The quick answer is yes. So I'll go through the estate assets in the slides is coming up. But yes, if the title of the property is in the deceased name, that would still have to go to probate. We're going to go over some quick estate planning strategies that you can prepare to avoid those sorts of situations. But in general, if the estate assets are above $25,000, then you're required to get a grant of probate. So we can get that net worth of the asset down below $25,000 through those strategies that we're going to go over later. And in that case, you would just have to sign a statutory declaration. That's just a sworn statement in front of a lawyer or notary, and then you would have authority to deal with the estate assets. Is that all right? Clear? Thank you so much for the questions, by the way.
Is there no way to avoid that?
Avoid the probate process?
Yeah.
So the question is there any way to avoid the probate process? So yes, we can try to move assets out of the estate so that it goes under that $25,000 threshold. For property, we'll go over it again later, but you can add, for example, your children on title as joint tenants. If you're in joint tenancy, that means you have the automatic right of survivorship. So the property would automatically go from the deceased to the survivors, so for example the kids, and in that case we can avoid the probate process or adding that value of the property into the estate assets.
Wouldn't that put up the taxes for the person who you bring in as the added?
So the question is about taxes, if you're adding somebody on title. So there's a lot of considerations when you're doing that. The main pro of adding, for example, children as joint tenants to a property is again to get that right of survivorship to avoid those probate taxes. But there are a lot of different tax considerations in that case where if you do that. If you do it normally, then the kids would, there'd be a deemed disposition, sorry, this is going a little detail, but there's going to be a deemed disposition in the eyes of the CRA where your children would gain, depending how many kids there are, if there's this one, 50% of the property as of the date of the transfer. So on paper, in CRA eyes, that's when they would get the property, and then if it's not their principal residence, any gain from the day they receive the property to the day they sell it would be considered or eligible for capital gains. So there's pros and cons of doing that strategy. Beneficiaries, these are who you want your assets to go to. So you can get real creative with this section, but mostly people think about property, like the houses, real estate, apartments, things like that. Some considerations, like you want to think about like the smaller details is if you want to give your property to maybe your nieces and nephews, do you want to give that with, if there's a mortgage on the property, do you want to give that with the mortgage, meaning that they assume the responsibility for those payments, or do you want the estate to pay out the mortgage and they get the property outright? Some small things like that. You can also designate specific items. For example, like art pieces, maybe have an antique desk, things like that. I would say baseball card collection, things like that. You can always designate specific items in your will to who you want to give it to.